Be ready. Start. Petitioners are companies stroke entities engaged in providing advertising spaces at various places. As per the petitioners, they had participated in the tender process for securing long-term license for advertising rights which are approximately for a period of 10 years. As per the petitioners, they had submitted their tenders taking into account the potential substantial earnings from political advertisements during the election period, and considering that there are 4 5 elections in the span of 10 years, they had accordingly calculated and submitted their bids. It is contended by the petitioners that the respondent number 1, Election Commission of India, has time and again clarified that there is no ban or prohibition on political parties from putting up their advertisement on commercially authorized sites. Reference is drawn to a memorandum dated 15/10/2013 issued by respondent number 2, the Chief Electoral Officer. It is contended that the respondent number 1, Election Commission of India, has issued the impugned directions to the respondent number 2, Chief Electoral Officer, Government of NCT of Delhi, to advise respondent number 3, Delhi Metro Rail Corporation Limited, to insert an appropriate clause in the contract with the petitioners, which is as under: no political advertisement shall be displayed, pasted at the space provided on lease for commercial advertisement during the period of Model Code of Conduct. If there is any political advertisement in the provided space, the same shall be removed immediately on enforcement of the Model Code of Conduct. Learned Senior Counsel for the petitioners submits that the clause 9.0 E of the agreement between the petitioners and respondent number 3 already contemplates advertisement during the period of Model Code of Conduct, and the said clause reads at under: advertisements pertaining to achievements by different governments, their departments, ministries, government undertakings, other authorities, or political parties shall be permitted. However, no advertisement of any political party, person violating Model Code of Conduct shall be allowed during the period whereby Model Code of Conduct has been enforced by Election Commission. Further, no advertisement which violates Model Code of Conduct shall be permitted during the period whereby Model Code of Conduct have been enforced by Election Commission. It is contended by learned senior counsel for the petitioners that if the impugned directions are implemented, petitioners would suffer grave financial loss. They would not be able to place any political advertisement even at the designated commercial spots, and the political advertisements would have to be taken down. It is submitted that such an action is violative of their fundamental right of freedom of speech and expression as guaranteed by Article 19 1A of the Constitution of India, and also their fundamental right to carry out any trade or business as guaranteed by Article 19 1G of the Constitution of India. It is further contended by the learned senior counsel for the petitioners that advertising in the commercially allocated seats is also regulated by clause 4C of the letter dated 7/10/2008 of the respondent number 1, which stipulates as under: if there is a specifically earmarked place provided for displaying advertisements in a public place, example billboards, hoardings, etc., and if such space is already let out to any agency for further allocation to individual clients, the district election officer through the municipal authority concerned, if any, should ensure that all political parties and candidates get equitable opportunity to have access to such advertisement space for election related advertisements during the election period. It is thus contended that the action of the respondent numbers 1 and 2 in directing the Delhi Metro Rail Corporation to incorporate a clause prohibiting any political advertisement at spaces provided to the petitioner for commercial advertisement during the period Model Code of Conduct is in force, and a further direction that in case there is any political advertisement in the provided space, the same shall immediately be removed, impinges upon the rights of the petitioners. Per contra, Election Commission of India in its affidavit has contended that during the general elections of Lok Sabha 2019, complaint regarding display of advertisements containing photographs of certain political leaders at various stations of Delhi Metro as well as inside the coaches of Delhi Metro was received by the Commission, and keeping in view of the responses received, the Commission issued the said letter dated 13/6/2019 in terms of paragraph 1(2.3.4) of the Model Code of Conduct Manual 2019, and thus prohibited display of election advertisements, hoarding, etc. on government premises, as also the premises owned by PSUs. Learned Counsel, appearing for respondent number 1, Election Commission of India, submits that the rationale behind issuing such a direction is that it should not appear to the public that government is supporting stroke endorsing any particular political party by permitting display of its political advertisements on government properties. It is contended that there is a direct nexus between the direction and the object sought to be achieved, that is, free, fair, and transparent election. It is further contended by the learned counsel for respondent number 1 that petitioners have a commercial contract with the respondent number 3 and do not seek to contend that petitioners intend to politically advertise, and as such the impugned directions of respondent number 1 and respondent number 3 do not in any manner affect the rights of freedom of speech and expression of the petitioners. Thank you.